Hello, beautiful humans. It's good to see you again. Today is Wednesday, June 25th, 2025, and we are going to dig into Lori Vallow Daybell's latest motion. Did any of you think it was going to take her this long to file a motion after everything was over? Now, I realized that I missed True Crime Tuesday yesterday. My deepest apologies. I ran out of time because I'm researching a case, but I am going to go live with that later this evening. I'm going to be covering the case of two kids who are missing from the FLDS community. We're going to talk about Warren Jeff's revelation and what it means for that community and the concern about these two missing kids and what we can do to help. Now, the motion that Lori filed for a new trial is not going to be surprising to anyone because, of course, she's going to file for a new trial. We're not going to be surprised that she's going to claim that she was too sick to defend herself. But what's going to be interesting about this particular motion is that she's going to reveal some of the information that was discussed during some of those sidebars we didn't get to hear when everybody had their headphones on and they played the white noise in the courtroom, as well as the hearing that was sealed that we didn't get to be privy to. Now, my speculation at that time was that some of that had to do with her health information being protected because there was an administrator from the MCSO there in the hearing that day. But I suspect it also had to do with another issue involving a potential witness that was going to come on. And so we're going to find out just a little bit of that information. And we're not going to spend a whole lot of time with it today because it's fairly routine. Nobody needs to be worried that Lori's actually going to be granted a new trial. I expect this one to be denied just like everything else has been. But it is somewhat interesting to hear, number one, what she's claiming, and number two, what was revealed in those little hearings over there. So here's the motion itself. I think this is the correct one. Nope, this is a minute entry. That's not what I meant to share. Sorry, guys. I really just want to share this tab over here. But for some reason, it's not. It's showing blank on my side, but can you guys see it? It looks like you can see it. Okay. All right. Glad to see Brandon supporting Colby so much. Those guys are really close, and I'm glad that Colby had that Brandon as a strong support system. So here we go. Defendant requests the court give her a new trial. Blah, 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 rules, articles, blah, blah, blah. Okay, here are the facts, or at least I'm going to put in quotes what Lori thinks are the facts. A, Fourth Amendment violation, medical evaluation. On Friday, May 30th, the defendant became ill, vomiting, at the lunch break during jury selection. After lunch break, the defendant informed the judge and state of her sickness and that her investigator had been out sick since the prior day with the same symptoms. Oh, so investigator Jeff White is the one that got her sick, apparently. The court asked the defendant to stay for 10 minutes while he informs the jurors and releases people with scheduling conflicts. The defendant was reluctant and did not want to vomit in front of the jury. However, the judge refused to dismiss her. The 10 minutes turned into 1.5 hours. Before being dismissed by the court, he advised the defendant to let the court know through her team before Monday if she was still sick. And I'm sure you guys remember that silly little hearing that went on. On Sunday, June 1st, the defendant was still sick and had her advisory counsel email the court to inform them that she was still too sick with a virus and could not proceed on Monday, June 2nd. Monday, June 2nd, 2025, the defendant was very sick and had advised the court in a timely manner. However, the court sent an order to the jail on June 2nd, 2025 to have the defendant brought to court by any means necessary. I'm sure you guys will remember us going over that as well. The defendant could not walk from being weak and dehydrated, having vomited all weekend. MCSO brought the defendant to court in a wheelchair. The defendant then explained to the court that she was too sick to represent herself and would not go forward. And just for 1 second, just because it's kind of silly, I want to just go ahead and play this clip.
Ready to proceed with jury selection?
No,
Why not?
I'm sick, Donna. I've been sick all weekend. I let my team know yesterday I was sick.
Can you please pull the microphone a little closer? I can't hear you very well.
I'm sick. I've been sick.
Have you put in tank orders to get treatment?
Yes.
So tank orders refer to court orders that direct a detention facility to address a defendant. Okay, we don't need to hear me talking in two windows. That's just silly. I want to go ahead and fast forward to the part where she invites the judge to come and check on her. He tells her, sometimes we're in positions.
Proceed when we feel under the weather.
It's not just under the weather. I'm very ill.
So Judge Boreski responds in the way that, okay, I get tired of hearing myself talk. See if we can skip forward and find my favorite part. Symptoms are almost as if she's thinking about which symptoms to say first or which symptoms.
40-year process, jury selection.
Would that waive my ability to represent?
I think it's really smart. It's still going to be her job.
Is expected of you at this point in the trial. Depending on how you're feeling later, we could talk about whether the opening statements would have to be further bumped to tomorrow. But I would like to keep this trial on track. So if you want a few minutes to talk to your advisory council, we can do that. Is there anything the state wants to put on the record before we do that?
Not at this time, Your Honor.
All right. Do you want to do that back in the tank?
Doing a good job representing myself.
I just want to point out that her voice. Okay, this person talks too much, so I can't find it. So we're just gonna skip. But that was my favorite. That was my favorite spot. Now, she actually was sick. I do think she was malingering a little bit. She was definitely, milking it as much as she possibly could. But that was the day that she said, well, Your Honor's welcome to come down to the jail and check on me. And he said, yeah, I'm going to take a pass on that. By the way, if you haven't seen, there is some merch available on if you go to the home page of my YouTube page and if you go to posts, you'll see a link for merchandise and the explanation of all that I don't have time to go over right now. But we do have it. I'll take a pass on that t-shirt as well as a Are You Done mug. So defendant then explained to the court she was too sick to represent herself and would not go forward. The court again asked the defendant to stay while he brought in potential jurors to explain and ordered her out of the wheelchair and into a regular chair. Defendant argued that the last time he said 10 minutes, which took over 1.5 hours, so he dismissed her prior to dismissing the jury. Defendant was then left in the wheelchair in a holding cell with no blanket, medicine, or hydration for 6 hours, awaiting for transport back to the jail. Now, I'm inclined to think that Lori's exaggerating this situation just because she has a history of doing that. But if they did, in fact, leave her without a blanket or hydration for 6 hours awaiting for transport, that's probably not very good given her illness. But again, she's a prisoner, so they have to treat her like a prisoner. On Monday, June 2nd, 2025, the court sent an order to MCSO requesting they medically evaluate defendant, a violation of this defendant's Fourth Amendment rights and Arizona Constitution. Actually, that's not a violation of her rights at all. June 3rd, 2025, MCSO called the defendant out of bed again to walk down to medical. Oh no. MCSO ordered CHS to evaluate the defendant's health without her knowledge. What? How can it be without her knowledge if she's the one who's actually walking down there to be evaluated? I'm guessing that the knowledge that the notice that they gave her was right then and there. We're going to be evaluating your health according to a court order by the judge. Hi, everybody. It's good to see you here. I miss hanging out with you guys. Yeah, Lori said she could only keep down oranges or citrus at this time. So then she says, MCSO ordered CHS to evaluate defendant's health without her knowledge. That's a repetition of the same sentence she just said. CHS then provided their evaluation to the court through MCAO's civil attorney, Joseph Vigil, which was a HIPAA violation. No. I don't think that is a HIPAA violation. Anyway, initially not under seal. On Wednesday, June 4th, 2025, this court ordered again defendant to court by any means necessary order to MCSO. Any means necessary order means guards show up at your cell and pull you out of bed, and take you to court against your will. I'm really glad she explained that any means necessary order in this motion, because I'm sure we all, including the court and the judge, needed to understand that better. That was sarcasm, by the way. Sorry. Snarky today. Once in court, defendant again informs the judge that she cannot proceed because she's too ill. Judge Boreski orders her not only to stay, but to defendant herself while too sick to do so. Defendant was then forced by the court to voir dire the jury and select a jury. I just want to mention that this is provided to me by Joe Schmo. I do have the means to go find it, but I always love it when he sends it to me because it makes it so easy. So I hope you guys are following his channel. He does a lot of really good reporting over there. Thursday, June 5th, 2025, although defendant was still suffering from a viral illness, she was expected by Judge Boreski to give her opening statement and begin cross-examining witnesses. Now, if you'll recall, she did have a little cough, and she was looking kind of sickly, and she was talking like this, except when she addressed the jury or the witnesses. And then she sounded just fine at that point. And she also had no problem coughing anytime that the prosecution was doing anything. But then when she was questioning witnesses, she didn't have any coughs at all to give. Then Friday, June 6, 2025, Judge Boreski ordered defendant by any means necessary to again defend herself sick in a full day of court from 9:30 a.m. until 4:30 p.m. It is so hard to actually have to work a full day. Sunday, June 8th, 2025, Defendant's Advisory Council again emailed the court that defendant is still sick and that she'd been notified by CHS of the results of the testing performed, came back with an infection in need of antibiotics for treatment. Yet again, a by any means necessary order was entered by the court for Monday, June 9th. And this is what would have been part of that sealed hearing, is the results of the test coming back with the infection needing antibiotics. Monday, June 9th, 2025, Judge Boreski cleared the courtroom and sealed the hearing, now that there was actual evidence that the defendant had really been sick the whole time without treatment. In the end, Judge Boreski still ordered the defendant to defend herself at trial, knowing she was too ill to proceed. The by any means necessary order continued from Judge Boreski, continued every day through trial from May 30th until June 12th, the day the verdict was given. This is a violation of the defendant's due process rights under the 5th and 14th Amendments of the United States Constitution and Article 2, Section 4 of the Arizona Constitution. This alone constitutes a new trial. Now, I don't think she's correct in her interpretation of the law here. And also, I'd be really interested, although I don't want her HIPAA rights to be violated, I would be interested to know what the doctor's actual assessment was. If she did, in fact, have a viral infection, which it sounds like she did, I'd be interested to know if the doctor who evaluated her made any determination as to her ability to sit in a courtroom and question witnesses. I'm guessing if any such evaluation was given, that it's likely the doctor probably said she's going to be just fine. She's going to take her antibiotics and she is capable of proceeding in trial. I'm sure they would have wanted to cover their butts with some kind of a statement from the doctor that said that she was fine. And I'm guessing that's what we're going to see in the order that Judge Boreski is going to respond to this motion for a new trial. I'm sure he's going to cover whatever the doctor told them about her ability to be in the courtroom. B, lack of impartiality again. Here we go. The court precluded this defendant from presenting her case by not allowing the defendant to argue objections, regularly denying sidebars, and not allowing her time to consult with her investigator and obtain documents from him prior to cross-examining. To begin, this defendant this defendant, in attempting to cross-examine the case agent regarding the investigation done at the scene by initial responding officers, was denied that opportunity. That's a long sentence. The initial responding officer spoke with a witness who provided a different description of the Jeep she saw during the incident. Defendant attempted to cross-examine the case agent when the state objected to the answer based on hearsay. The objection by the state was sustained. Defendant, even though not having been asked for a response from the judge, argued the statement was not being used for the truth of the matter, Your Honor, rather to show the effect on the listener. Defendant requested a sidebar and was denied. The same interaction occurred with another scene agent, Detective David Ferrer, when defendant attempted to cross-examine him regarding what other neighbors told police they heard during the police investigation. A hearsay objection was sustained without allowing defendant an opportunity to respond. And again, a judge is going to tell Lori, just because the state's objections are sustained against you and your request for a sidebar is denied, doesn't mean that there's a lack of impartiality. Lastly, defendant put on the record early in the case that her investigator, Jeff White, had been out ill. The court requested defendant's advisory counsel work with investigator White to obtain documents and exhibits she would need to cross-examine witnesses. Photos were received by advisory counsel and were not able to be printed in time to use during the cross of Detective Ferrer. Those exhibits are attached as Exhibit 1. Defendant also was unable to admit other exhibits, and the state and the court continued to state she would be opening the door to her prior convictions. Well, she would have been. Additionally, the state continuously stated defendant's line of questioning related to Melanie Boudreaux constituted a third-party defense, yet the defendant never attempted to blame Melanie Boudreaux for the crimes. Defendant was simply attempting to cross-examine the victim, Brandon Boudreaux, as to why he blamed the defendant. Abusive discretion. Denial of Rule 13.5. On May 29, 2025, after reviewing electronic questionnaire, defendant requested a probable cause hearing on aggravating circumstances pursuant to Arizona Rules of Criminal Procedure 13.5a. The court denied the request, stating that the defendant was not entitled to a probable cause hearing. Thank you so much, Kelly Collins, for that super sticker. I appreciate you. And sorry for all the flubs. I am trying to go fast here because I do have to take a kiddo to a thing. 2, not releasing the jury from the admonition on the record. After the verdict was read June 12, 2025, the court dismissed the jury so that the parties could discuss whether an aggravation phase would be presented. After discussion relating to the denial of 13.5, the court set a sentencing date and dismissed the parties without bringing the jury back into the courtroom to officially lift the admonition and dismiss the jury. And I agree, that's true. That did not happen on the record. I don't know if it has to happen on the record in order for it to take effect. I would just guess that this is an error that she is pointing out, just to throw everything at the wall and see what sticks. Number 3, allowing GSR and DNA evidence without sufficient foundation and denial of right to confront witnesses. On May 3, 2025, the state filed a motion to preclude Brady material relating to the crime scene tech Tammy Lichick from Gilbert Police Department, who collected material evidence from the alleged crime scene. I knew she was going to bring this back up at some point. Brady material showing that the witness, Lichick, was implicated in an incident that resulted in her resignation was disclosed by the state on May 1, 2025, even though the report was concluded on March 6, 2025. Because of the late disclosure, defendant requested the court to order the state to disclose the witness Lichick's employee file so that defendant could thoroughly investigate any issues that might be relevant to this witness testifying at trial set to begin May 29th. The court denied this request. Again, a denial of request is not lack of impartiality. May 25th, 2025, the state notified defendant that 2 pages of this witness Lichick's notes, which other forensic scientists would have needed to rely upon or had relied upon but were now missing and could not be provided to defense. On June 3rd, in the middle of the trial, the state disclosed a letter from the witness indicating she would not be testifying. Defendant objected prior to each forensic scientist, 2 from Mesa and 1 from Phoenix, to the witness testifying about analysis they completed based on the work conducted by witness Lichick. The first witness, and this was the blood blots collected by Tammy Lichick at the autopsy, collected by Sapinoso at the autopsy. Second analyst was Vanessa Mielke, who testified that the blood blot matched the DNA swabs, and finally, analyst Kyle Mueller, who testified about GSR particles found inside the Jeep that were collected by witness Lachik. Those objections were denied. And so if you remember, the state was able to bring in all of that evidence that Tammy Lachik collected because she was being supervised by the case agent at that time and Detective Pillar, and he was the one who testified as to the collection of all of that evidence. Getting a little sass from my 15-year-old. But it's okay. Okay, Fourth Amendment violation, medical evaluation. New trial is appropriate if for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. I don't think that applies here personally. By forcing defendant to proceed with trial as her own counsel deprived her of the right to effective assistance of counsel. Judge Boreski has already ruled on this. He's already said she can't claim this as something on appeal because she's representing herself. There is no honor in forcing this defendant to defend herself sick. There is no honor in ordering by any means necessary to ensure that you will be the judge to preside over this high-profile case. There is no honor in threatening defendant over and over that you will inform the jury she was convicted of prior murders. Where is the honor in this court system? Question mark. Then she goes over lack of impartiality, and this is all stuff that we've heard before, that she wasn't asked for responses to objections, that her sidebar requests were denied, and multiple judges, 3 judges at this point, have ruled on this already. Any attempt to present defendant's case was met with threats of informing the jury about the defendant's prior convictions. Then she claims that the denial of a Rule 13.5 is an abuse of discretion. And then she also says they should have released the jury from the admonition on the record. I agree with that, but I don't think it's grounds for a new trial. And then finally, the GSR and DNA evidence, she wasn't able to confront a witness about that. Finally, the state of Arizona does not honor the Constitution of the United States. The state of Arizona does not honor the constitutional rights of the accused or even the civil rights of the accused. For this purpose, a new trial is required. Now, knowing Judge Boreski as we do, I'm sure that he covered all of his bases in making sure that Lori received proper medical attention. And thank you again for this second super sticker. And thank you, Miss Angry Seth, for the super sticker. I'm sure that Judge Boreski got a full medical report. I'm sure that he had the physician evaluating her note her condition and her ability to be in court and to question witnesses. And so I'm sure that we're going to see in the judge's response all of that information come in. So just to recap, and for those of you joining us a little late on the thumbnail, I made reference to the fact that we were going to see and hear. So we're going to hear with our own ears and see with our own eyes what was discussed at that sidebar and in the sealed hearing. And so now we found out that it was her medical information that was going to be discussed. So this is all more than expected from Lori, and I hope that we get a response from Judge Boreski soon. And then, I don't know, let's have a poll and figure out how long is it going to be before we get yet another motion from Lori, because we all know she's not going to go quietly. She is going to keep filing motions until they make her stop. I have to run, guys. Thanks so much for being here. Sorry I didn't get to interact with you much in the chat, but I'll be back tonight around 8:45-ish Central Time for a report on the 2 missing FLDS kids and what we as a community can do about it. I'm excited to reconnect with you guys. And one more time, we're going to hear the judge deny Lori.
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else?